let's move now to the big day is approaching. And certainly, first of all, how do trials get scheduled? Let's start there.
Well, I mean, a lot of that, again, is dependent on which judge you're in front of. But I would say in most circumstances, it happens through some type of agreed order or a scheduling order where, our office and the attorneys on the other side get in touch with the court administrator. For those that don't know, a court administrator is sort of like the gatekeeper to the judge.
They keep the schedule.
Right. We don't get to talk to the judge typically.
Right.
If I'm setting a trial, I don't call and say, "Oh, hey, Judge Smith, let's do that." Like, that's not how it works.
Right.
You talk to their court administrator, and they hold the keys to everything.
Yeah.
And then you're having to coordinate a day or a number of days that is available before the court that also work for our calendar and counsel opposite's calendar.
Right.
And sometimes that's difficult.
And if there's a lot of lawyers involved, it's going to take longer to get something set. If you live in a busy metropolitan area, a larger metropolitan area, it might take longer to get a trial date scheduled. And they don't always, just because I call and say I want a trial date, they won't always just give you one. Sometimes they want to make sure that you've completed the formal discovery process, the information gathering process. Sometimes they won't. Sometimes they'll set a trial the day you file your complaint. It just really depends on where you are. And that's why it's super important to talk to an attorney, work with an attorney who is very familiar with your local area. And that doesn't necessarily mean they live there, but there's got to be a high level of familiarity with the court administrator, their tendencies, the scheduling, how long you're waiting for a trial. So again, just because we want to set a trial doesn't mean that we're always immediately able to do that.
Right. Some courts will put a defined amount of time that each side has to either put on their case or also cross-examine, witnesses from the other side. So in that instance, if let's say you set a 3-day trial and the judge says, okay, each side's getting a day and a half, or each side is getting 10 hours or something like that, you're on a clock and that thing is going to finish in that 3 days. Some courtrooms are run differently, where once they blow the whistle, the plaintiff starts and they're going to get to dictate the pace of the case a little bit, until they're finished.
Well, Matt, you said that. So just for our listener, the plaintiff is the person who files first. And the advantage in filing first is you get to go first at trial. It's kind of like baseball, that the visiting team bats first. And in baseball, you want to be the home team, you want to bat last. But in a trial setting, if I get to choose, I always want to go first, because you get to set the pace. You get to tell the story first.
Yeah.
And that's important.
You get to draw first blood. I mean, I think there's pros and cons to each. Right. I agree with you. I guess if I had my pick, I would probably prefer to be the plaintiff. I think first impressions matter. You get to get out there first. You're in front of it, and you get to set the pace. However, if you're the defendant, don't worry. These are small differences.
Yeah, everybody is going to have their opportunity to say what they want to say within certain reasonable parameters. But again, you might not get to choose. It's a luxury if you do get to choose. Like Matt, I tell people, I'm a fullback. I want to run right at you. So give me the ball. Let's go first. And that's just my mindset. And again, that doesn't mean that if your spouse filed first, that all of a sudden all is lost, because it's not.
Right. I mean, look, if you're the defendant, arguably you're getting the last word.
Okay? You get to hear everything before you have to speak.
Yeah, right. You get to know, from the attorney's perspective, I get to see the story that's been put on first. And so sometimes I know, okay, how many points do I need to score? What type of risks do I need to take here?
Or they've taken their best shot at you, and you don't even have to put on your case because they haven't been able to meet the burden that they have. If I know they've
punched themselves out and there's just nothing left for them to do, I don't have to bring out something that's super risky. I might know exactly what has to be done in order to win that case.
Right.
Sometimes maybe something didn't go your way early on, and I know that I've got to throw a Hail Mary. There is an advantage sometimes to knowing that you're having to throw one, as opposed to if you're going first, You just got to try to score as many points as you possibly can.
Right. And so I think the moral of the story is, guys, that you trial preparation starts before the day before the trial, right? We've talked about all the information gathering process and sometimes the difficulty of actually getting a trial set. But Matt, let's say we've got a trial set that, of course, you've put that day on your calendar because it's a big event. You want to make sure that you take off. If you've got a 3-day trial, you're going to want to take off certainly the 3 days of trial, but you might also want to consider taking off a couple of days before the trial. You also might want to take a day off after the trial for recovery because it will be one of the most difficult events in your life, honestly. If you have to journey through a divorce trial, it will be just exhausting, exhilarating, emotionally complicated. It's going to challenge you, that's for sure. And you're going to want to be preparing in advance of the big day.
Right.
And so let's talk through, Matt. We've got a trial set. Again, we just settled a case that was set for trial. And so what starts happening is we start digging back into the discovery, the information that has been exchanged. We're going to be wanting to tweak and update your financial statement. And we're going to be wanting to pull out the key pieces of information that we're going to need to be able to tell the story.
Right. And those are the things that are ultimately going to be offered into evidence.
That's right.
And the way I explain it to people is you're going to be telling your story, and then the evidence that we're going to offer before the court, those are things that are going to support your version of things.
That's right.
Okay. So, I might not need to put into evidence every single financial transaction that supports my client's story. I might only want to put in the top 3 or 4, that sort of paints a picture for the court as to what we're talking about.
Sure.
If you tried to put in every single one from over the course of a 10-year marriage, you'll be there for weeks.
Right. We have to be mindful that you are given a window of opportunity to tell this story. And like you pointed out earlier, sometimes you're on the clock. And so we have to, you can't always say everything that you want to say, and you can't always use every piece of paper that you want to present to the judge.
Well, and I mean, we talked about, setting the pace if you're the plaintiff. Well, just like in any good story or movie, you want to be mindful of your pacing, because if you're sitting there and you're just getting bogged down in, hours worth of, minutia and going through these little individual transactions, you're probably losing your audience.
Yeah, and your audience you're an audience of one, right? The judge in a Mississippi family law dispute is your audience, and you've got to present the information to that audience in a way that they can understand it, they can digest it, they can consume it, because you'll be asking them to make super important decisions.
Right. I was taught early on, that you want to make sure as an attorney that you are paying attention to the judge.
Absolutely, yeah, for sure.
In a lot of ways, it's juggling, because you're asking questions, you're listening for the responses, you are listening for objections, and you're also trying to pay attention to the judge. I can usually tell, when a judge is not interested in things that we're talking about anymore, because you'll see it in their body language. They'll put their pen down. They'll push their chair back away from the bench. Sometimes
they'll look at their phone.
Right. Some judges have computers that are up on their up at the bench, and I'll notice that they're paying more attention to something on their screen as opposed to what we're saying.
Right. If they're playing solitaire, we might want to move on to the next thing.
At the same time, sometimes you touch on something and I can see their ears perk up.
Right.
And it's
eyes get a little bigger, ears twitch.
Right.
What are we talking about now?
They want to hear more about this.
That's right. That's
okay,
true.
so let's talk about this.
Yeah.
So sometimes you you definitely want to plan as to what you're going to do, but I also feel like you have to grant yourself certain flexibility to move on from a subject or dive deeper into a subject if it calls for it.
Right. When I was a young lawyer, I would almost script every single question that I had. And again, for all the reasons that you just said, that can be handy to have a script or to have a guide, but you've got to be able to adjust on the fly based on how much time you have, how the story is unfolding, whether the judge is interested in that particular point.
Right.
And so you want to make a plan, but you've got to be prepared to deviate from that plan. And so again, if we've got a divorce trial, we're going to be in constant communication. We're going to have you in the office. We're going to be practicing your testimony. We're going to be talking to all the witnesses. We're going to be pulling together the discovery. We're going to be updating your financial statements. We're going to see what key pieces of information, photographs, audio recordings, video recordings that we're going to need. Matt, take us to the day of trial from start to finish. Well, even before that, in the days leading up to the trial, what's happening?
Right. So in the days leading up, obviously, most likely your attorney's office is going to be marshaling all of their resources to getting ready for that big event.
Oh, yeah. Ours was, literally just a wreck because we had demonstrative evidence, blown up documents, and just paper everywhere.
Boxes everywhere, right.
A little organized chaos, really.
Right. As you're leading up to let's say the day before trial, you're getting ready to land the plane. You've made your copies of your exhibits. You've probably got an order in which that you're going to want to try to put them into evidence. You've got an idea of what witnesses you want to call first and what information you're going to try to get from them. I would say certainly for the parties, the night before you need to do your best to get a little bit of rest.
Yes,
you need to make sure that you have eaten something, that you're hydrated, and get as much rest as you possibly can.
Avoid alcohol. Certainly drugs,
right.
But anything that's going to disrupt your sleep, disrupt your ability to get yourself mentally, physically, spiritually ready for this event is going to be super important. I can't stress how much, if you don't remember anything else that we say in this podcast, how important it is to practice great sleep hygiene when leading up to a trial, because you're just going to need to be as rested as you possibly can be. And it's going to be really hard to sleep, but being able to sleep and going into this event, because let's face it, everything. You know the story that it is that you're going to be trying to tell. Right. And so being rested going into this stressful event is super important.
Right. Yeah. It's their lives. That's what we're talking about. So I tell people we're going to tell the truth, and you want to have as clear of mind as you possibly can. Okay. So, whether you shower the night before or the morning of, whatever, I suggest take a shower.
Shower.
Get dressed. You need to wear something, like you're going to a job interview.
Yeah, and that's a big question we get. Well, what do we wear? Even in our most recent case, we had our clients sending us, hey, should I wear this? Should I wear that? And that's important, Matt. What advice would you give to men or women with regard to what they should wear to the big day, to a trial?
You want to wear something that I think reflects your feelings about the event that you're about to take place in.
Yeah, you want to take it seriously.
Right. I'm not saying you have to show up in a 3-piece suit or a tie, but you want your clothes to be clean. You want to wear closed-toe shoes.
Yeah, if you have facial hair, you want it to be neatly groomed. You want to try to avoid flashy jewelry. You want to, if you're a mama and you're in a contested custody case, I tell my clients, dress like a mama. And what you'd be wearing to First Baptist Church in Jackson on a Sunday morning is more than likely going to be appropriate. Mississippi is a very conservative state. I have no problem with body art or piercings or tattoos, but again, you want to minimize that. You want to look as conservative as possible and dress for the occasion, because it's a super important occasion. And like I said, you don't have to wear a suit and a tie, but you certainly want to be neat, professional, and also comfortable, because it certainly is a very uncomfortable endeavor to walk through a divorce trial.
Well, I think most people just assume that the only thing that's important are the things that they say when they're on the witness stand. And while that is incredibly important, what you say while you're on the witness stand, you have to understand that you are being observed and watched basically from the moment that you get inside of that courthouse.
Well, really from the time you step out of your car. And Matt, I'm glad that you brought us. So we're at the day trial. You've pulled up into the parking lot, certainly every courthouse in Mississippi is a little different. Some are modern, some are more historic. But from the moment you step foot out of your car, there are deputies, there are clerks, court reporters, court staff, there are court administrators. This is a small community when you're stepping into a courtroom. So it'd be like coming into our office. We've got just 6 or 7 people. It's the same way at a courthouse. I mean, the staff is usually going to be relatively small, 4, 5, 6 people, and they're paying attention. Oh, these are the Smiths. They've shown up for their trial today. Whoa, what is she wearing? Whoa, look at that jewelry. What about that tattoo? What's that crazy hat he's wearing? So the minute you step out of your car, you're on trial, and you need to act that way.
Right. You are already telling your story.
Telling your story. I agree.
Be aware, most courthouses in Mississippi, you're not going to be allowed to bring your phone in.
Yeah, that's a great point. You want to leave out, if you wear an Apple Watch, if you have a phone, iPads, computers, you need to be in conversation with your attorney because each judge, each courthouse is different. But generally speaking, Matt, wouldn't you agree? No phones, no Apple Watches, no electronic devices.
And I mean, number one, I'm trying to save you a trip back to your car.
Yeah, no pocket knives, no large guns.
No
the small
weapons.
guns are fine. No guns.
Also, I've seen people get, kind of thrown just because they weren't expecting something.
Right, pocket knife or something like that. Something simple.
Right, you pull up and you can't find a place to park. You're struggling and maybe you're running a little behind, and then you've already got this enormous event that's getting ready to get started, and sometimes all it takes is just one little thing to kind of tip over your apple cart.
Ma'am, I'm going to have to get you to take that Apple Watch off and take it back to your car.
Yeah, right. You
can't have your phone. So, think about childcare. I mean, these are the kind of things that you're going to have to plan ahead. Now, you're a parent, and look, you might not be at carpool at 3 p.m., so you've got to plan accordingly for your children.
Right.
And simple things. Like I said, if you have a pocket knife, leave it at home. Don't wear your Apple Watch. Wear a different kind of watch, or don't wear one at all. And so again, but little things can throw you off. And if if it's already a stressful, chaotic day, and when you're walking through security, all of a sudden they say, "Ma'am, I'm sorry, you can't have that watch," and you have to take it back to your car. Again, that can throw you off. So you want to think about and prepare for those things ahead of time.
Just minimize the distractions, minimize the things that can, tear away your focus.
Yeah.
Okay.
And so Matt, So we're at the courthouse.
Right.
We the very first thing we're going to do is we're going to walk through security. You've talked about that. You can't have certain electronic devices. It's not as bad as trying to get on an airplane, but you can't have pocket knives. They may or may not allow you to bring in like a drink or water or coffee or something.
You're
like that.
You're going to go through a metal detector. Somebody's going to look through your bag if you have a purse or if you're carrying a briefcase or something like that. Be prepared for those things. You mentioned earlier about how in a courthouse ecosystem, there's lots of different players that are constantly there. You need to treat everybody with dignity and respect.
Absolutely.
You should do that anyway. Just
but
period.
Especially on the day of your trial.
I can assure you, those people talk to one another. The court, when I say the court, I mean the judge, is aware of how you're behaving, how you're treating people.
Yeah, they're human beings. They talk to each other.
If you decide you're going to dress some, a security guard down because he's told you that you have to take your phone back to your vehicle, and that's just unacceptable to you because you have to be able to look at Instagram, they're going to hear about it.
Right.
Okay. And that is, right or wrong, that can affect or tint the way that the court, views you. Once you get there, we're going to get through the metal detectors. Usually, you and I, we're going to try to get there early enough where we can get you into what we would call a witness room.
Right. And different courthouses, again, are set up differently. Some are super modern and have great accommodations. Some aren't, and some are more difficult to navigate, and some you're going to be with the masses, so to speak. And so, but ideally, we want to try to get you in and get you into a private space if we can.
And actually, something you just said made me think, talking about the dress code, plan for layers, because some courthouses are incredibly warm and hot. Some are frigid.
Right.
And so you want to be
comfortable.
You need to bring a little, a jacket with you or something that you can easily take on or off.
Good point.
To stay comfortable.
Yeah, I agree.
So once we get you into a witness room, if we can find one, there's usually going to be something called docket call. That's where the judge is going to call out different things that are
roll call. Like
day.
think back to high school where they're going to call roll. We're going to call the cases. We're going to find out how much time each case is going to take. And sometimes you might be the only thing on the docket, which is the court's official list of cases that it's reviewing for that particular day. Sometimes you might be fifth or sixth down the line. And they could be super short things. It just really depends on where you are and why you're going there. And that's something that we try to check ahead of time. But emergencies come up. You could be scheduled for a 3-day divorce trial. And then on the first morning of the first day of trial, the court has to deal with an emergency that takes up a lot of the time. So, we have to plan, but when we get to the actual event, we have to be prepared to adjust.
Right. Before most trials start, there may be a conference in chambers, and that's where the lawyers for both sides go back into the judge's office.
Yeah, it's where the judge is going to want to hear kind of the coming attractions.
Right.
Like, hey, Matt, why are you here today? What's this case about? What's in dispute? Is this really a custody case? What are we fighting over today?
Right. And, from the attorney's perspective, that's one place to kind of start laying, some groundwork. I mean, I know that I always make sure that I don't say anything in chambers that I am not prepared to prove. And I believe, after doing this for 15 years now, at least the judges that I'm in front of primarily, they know that if I'm saying something in chambers, it's in one of the dozen boxes that I've got, sitting out by my table. So you're going to get to, start telling the story a little bit, there in chambers.
And that depends. It doesn't happen every time. But it don't be thrown off if it does. And so ideally, we're going to put you into a private room. Sometimes we have better rapport and dialogue with counsel opposite. Sometimes we don't have any rapport or dialogue with counsel opposite. Sometimes the judge is going to want to talk to everybody ahead of time and kind of hear the elevator speech of the case beforehand. Sometimes they're not. It just really, really depends on who the judge is and where the case is. And unfortunately, the answer to a lot of questions is it just depends. It depends on the day, depends on the judge, depends on the location, depends on the case.
And you're just going to have to trust your attorney to assess that circumstance and draw from it what they can, if there is anything to draw from.
Right.
Okay.
Sometimes there is, sometimes there isn't.
Right.